So, Vipal, my first question is, at least in terms of crimes that he has pled guilty to now, we did a story last year where there are literally thousands of people who are caught red-handed lying on these 4473 forms that go unprosecuted by federal prosecutors. So is there an increased effort by the U.S. Attorney's Office here in the Southern District of Ohio to prosecute these now, because we've seen two high-profile cases with Mr. Kollie, with also the gun that federal prosecutors say was used to murder Detective Del Rio? Is there increased attention on that in this district lately?
Yeah, if you look back at the history of charges brought by our office, and you can do that by just going to our website and looking at the press releases that we've posted, I actually think if you go back and look at that, you'll see that for the last several years, this office has brought charges based upon lies and false statements on ATF 4473 forms, like the charges in this case. And so I don't know if you'll see, statistics-wise, a dramatic uptick in false statement or false document types charges. I mean, it's always been a serious offense, and it's something that this office and law enforcement agencies have taken very seriously. And like I said, if you go back and look at the history of the types of cases this office has brought, what you'll see is that when there are serious offenses, this office has responded and brought charges accordingly.
But would Ethan Kollie be in that courtroom today if he were not a friend of the Dayton shooter?
I can't go back in time and predict what would happen. I can say that the charges followed the evidence, and the evidence indicated that there was a violation, and that violation obviously had serious consequences. So I can't predict what would have happened.
Defense pushed for 33 to 41 months. What would your recommendation be, or what are you hoping for sentencing?
Yeah, let me just clarify that. That's actually not the defense pushing for that or arguing. That's not their advocacy. What that was a reference to is the sentencing guidelines, which are promulgated by something called the United States Sentencing Commission. That is the number you heard, 33 months to 41 months imprisonment, is the defense estimate of what the advisory guideline calculations will be when we get to sentencing. And then, as the court indicated, that range is something that the court considers in determining what the appropriate sentence is.
Do you agree? Is that a correct range? Is that a likely range?
That is a likely range. I don't have any reason standing here today to dispute that.
So 34 to 41? 34 to 41 months?
33 to 41 months is the sentencing guideline range that we believe will apply when we get to sentencing. Ultimately, that's the court's decision. And as for your question, I think where you're going is, what will we be advocating? What would we like to see? And then what we want to see is a just sentence, and it's just too early to tell exactly what we'll be advocating for at this point.
So, Vipal, these charges came out of the investigation into the Oregon District mass shooting, but to be clear, he is not charged in connection with the actual shooting.
That's exactly right.
It just stemmed from that investigation.
That's exactly right.
Three items were mentioned in the original indictment: the body armor, the magazines, and a receiver for the AR weapon that was used in the mass shooting. Were any of those investigated? Were any of Mr. Collie's forms incorrectly filled out for those three? I'm trying to figure out why those three were included in an indictment on an unrelated gun charge.
Yeah, so to clarify, the complaint that was filed made reference to those three items you mentioned: the body armor, the upper receiver to the AR-15, and the 100-round double drum magazine that Mr. Betts ultimately used in the shooting. The reason there are no charges like the ones Mr. Kollie pled guilty to today relating to those three items is because there is no form, like there is when purchasing a firearm, for body armor, upper receivers, or magazines. So there was no requirement to fill out a 4473 form for those items. In fact, many of those items can be purchased on the internet. It's the lower receiver of the AR rifle that constitutes actually the firearm under the federal definition.
But it wasn't as if those were, he was never charged for buying those items and stashing them for Betts. It wasn't like they were dropped in exchange for the plea. He was never facing charges for buying those items for Betts.
That's right. There was no dismissal of charges as part of this plea agreement. There was no dropping of charges. that was just something that we were not able to charge for. So what we had evidence for, what we could prove beyond a reasonable doubt, we charged.
But
And
things
he
you
pled
all
guilty
believe he did, but they're just not criminal.
That's right.
And why include them in that criminal complaint then?
The criminal complaint is to establish probable cause for violations. Part of that process is, of course, telling the magistrate judge as much of a complete picture and background and story. So it's part of the narrative behind the offenses charged, and that's important for the magistrate judge to know.
Any projection on what the judge may decide as far as release?
No, I don't have any projections.
Can you expand upon your concern that he might be still a danger and you don't want his release before the sentencing?
Well, as what was argued in court, and we've argued this before because this issue has come up, this is not the first time that the issue has come up, and our argument, as you heard in court, is that the law that applies subsequent to a conviction, which a guilty plea is that the defendant shall remain in detention unless the defense is able to show by clear and convincing evidence of the lack of danger or lack of flight. And as you heard in court, the government's argument is that the drug use presents still a danger to the community, and we made that argument and stand by it.
Is there anything we did not ask you, Paul, that you want to mention?
The matter is set for sentencing now, and that's the judge set it for sentencing on February 20th at 2:30, and this matter now will be, as the court said, referred to the probation office. There'll be a report generated. The parties will get that report, and the parties will have the chance then to make their pitch or their advocacy points to the judge, and we look forward to that process occurring and proceeding towards sentencing.